Hi, I'm Anna Denton-Jones of Refreshing Law, and in today's session, I'm going to be talking about a recent case involving somebody called Maya Forstater in relation to an Employment Tribunal claim she brought against an organisation called CGD Europe in respect of her religion and belief. In this case, belief. So belief is a protected characteristic, potentially, under the Equality Act of 2010 here in the UK. And essentially, what a judge is being asked to do in a tribunal case is make a distinction between a couple of different things. So, was the reason why somebody was dismissed, for example, because they held a particular belief? Obviously, if that was proven, it would be direct discrimination and unlawful for the employer to have dismissed for that reason. But obviously, employers tend to argue, no, it's not what the person believes that's at issue, it's the way they behaved. So some kind of manifestation of that belief becomes a conduct issue. So, for example, we've had a case recently, the Macareth case, where the employee was refusing to use the particular pronouns that they were required to use in recognising somebody's gender, or colleagues perhaps who have proselytised and sought to influence their colleagues' beliefs in the workplace, for example, the Wastony case. So essentially what a court is trying to do in those kind of cases is to decide which side of a line the particular facts of the case fall. So when the person has behaved in a particular way, when they've manifested their belief, did they do it in a way that was somehow objectively offensive, unreasonable, or inappropriate? That's the kind of language that the judges have been using. In this Forstater case, she was a consultant, and her belief was that sex is a biological fact that you're born with, it's a material reality, and it can't be a matter of identity or feeling. She did recognise that through the gender recognition legislation, it's possible for somebody to legally change their gender, and she told the tribunal that she would respect somebody's pronouns, but essentially her beliefs were strongly in favour of women's rights, and particularly of concern for her was female safety in certain same-sex spaces, for example. I'm sure you're familiar with the kinds of debates that have been going on around the consultation that took place into whether or not our gender reassignment legislation needs to be tweaked in some way here in the UK. So her case involved a couple of different decisions. The first stage decision was that her beliefs deserve to be protected in a democratic society just as much as anybody who believes the opposite to her. So there's a real freedom of speech kind of vein running through that. The second decision that then had to be made was whether or not what she actually did, how she expressed those beliefs, hit that threshold test of being objectively offensive in some way. So what is it that she'd done? She'd been quite vocal. She'd expressed her opinions on Twitter and in social media in quite a strong way. She'd brought a booklet into the workplace, expanding on that kind of lobbying around those issues. And as often the way with social media, she'd circulated video clips and things like that. But as I said, she had told the tribunal that she would respect somebody's pronouns if necessary. The judges decided that she hadn't overstepped that line into the objectively unreasonable territory, that actually what was going on here was just this normal, robust debate that you get when you disagree about something, and the words common currency were used. We're all used to, particularly on social media, seeing different camps with very different views expressing those views. And essentially what the judges don't want to do is stamp on that free speech. So in her particular case, it was found that her dismissal, or it wasn't a dismissal, it was a failure to renew her contract as a consultant, was because of her having expressed her beliefs in the way that she did. So in that case, the employer was found to be in the wrong. But that's not to say that every case like this would fall that side of the line. It, as I said, it is going to come down to the facts of the situation. She was also bringing victimisation claims. Her protected acts that she'd done were obviously bringing the claim in the first place, but things like crowdfunding it and essentially defending herself. As a result of her doing those things, the organisation took her down from their website. So that was found to be the act of victimisation. She wasn't successful in her harassment claim. The employer had commissioned a report into the background to all of the issues, and that was found to be a sort of reasonable step for the employer to have made to investigate what was going on. It is worth noting, however, that there was some criticism around the production of that report, and that it was sort of commissioned and published to the employer without them having given Forstater the opportunity to comment on the contents of it. So note that angle. Lots of the coverage that you'll see of this case will be around the, she was discriminated when she raised her views kind of angle, rather than focusing on it's about which side of this line you fall in a very fact-specific way. Worth noting that in respect of her Twitter account, for example, she did have that statement in her settings, in her profile, that disclaimer to say that she was expressing her own personal views when she was doing so, not the views of any organisation that she worked for. So that helped her, I think, in that respect. Also, her job didn't involve being a spokesperson for the organisation or anything like that. That might be a factor that would change which side of the line her case fell. So if she was in a more of a leadership role, perhaps that might have had an impact. It is a first instance decision. The employer is thinking about whether or not they're going to appeal, and it is undoubtedly the case that at some point in the future the higher tribunals and courts are going to comment on the issues that arose in this case. So we all have to watch this space. In terms of where does it leave employers trying to manage these situations, I think the thing to take away from this case is let's focus on what the problematic conduct is that somebody is engaging in rather than the expression of their beliefs. Why is that conduct problematic? Is it the case that it's upsetting lots of other people? People are refusing to work with this individual. Grievances are being raised. What is the problematic impact so that you can persuade a judge, if you ever needed to, that it falls that line of being objectively unreasonable, rather than it just being somebody's got a different view to you and what they say is unpalatable, but nevertheless their view is going to be protected by the law because they're entitled to have that unpalatable view. So that's the fine line that we're all treading. If anyone's got any further questions, it's adenton@refreshinglawltd.co.uk. Thank you very much.